Clerk, I'd like to nominate Deputy Colm Brophy to be our chairman for today.
Are there any other nominations for temporary chairman?
No, second that.
I therefore call on Deputy Brophy to take the chair.
Thank you very much, colleagues, for your nomination. We are in, obviously we are in public session, and the purpose of today's meeting is to consider the Gender Pay Gap Information Bill 2019. Before we begin, just to remind members of the long-standing parliamentary practice to the effect that members should not comment on, criticise or make changes against either a person outside the House or an official either by name or in such a way as to make him or her identifiable. Also, just to remind people in relation to switching off your mobile phones. And I have apologies received today from Deputy Fitzpatrick. Now, we are joined today by Minister of State of the Department of Justice and Equality, David Stanton, and his officials. You're very welcome. And as there are no amendments received to the proposed bill, would the Minister just like to go straight away to making some opening comments?
Yeah, thanks very much, Chairman. I haven't got a whole lot to say at this stage regarding opening comments. The bill is fairly straightforward. Obviously, the programme for partnership government includes a commitment to take measures to reduce the gender pay gap and to promote wage transparency by requiring companies of 50 or more employees to complete a wage survey. This commitment is being implemented by means of Action 1.23 of the National Strategy for Women and Girls 2017-2020, on which the government is to promote wage transparency by requiring companies of 50 or more employees to complete a wage survey periodically and report the results. And the main provisions of the bill then are that the Minister will have power to make regulations to require public and private employers to publish information setting out the differences between the mean and median hourly remuneration of male and female employees. The reporting requirement will apply on a phased basis, beginning with employers of more than 250 employees, then reduced to employers of more than 150 employees and to employers of more than 50 employees. The reporting requirement will include both full-time and part-time employees when relation to bonus payments and benefits in kind. The bill requires an employer to include a narrative setting out the reasons for the gender pay gap in the firm and the measures, if any, being taken to address that gap. And the bill also provides for a number of enforcement mechanisms. An employee will be able to make a complaint to the Workplace Relations Commission. The Irish Human Rights and Equality Commission will be able to apply to the Circuit Court to require an employer to comply with regulations where it has reason to believe that an employer has failed to comply. I have a number of issues that I wish to raise as we go through the bill that I want to bring further consider for report stage as well.
Well, we're going to commence going through the sections now at this point. So if there is anything, please indicate. So, Deputy Chambers.
Just thanks, Chair, and congratulations on your new additional responsibilities.
Every move.
Additional responsibilities. Just a quick question on the. First of all, when do you expect it to be commenced, and when would this information start to become available? Whenever. That's the first question. Well, just on, you mentioned, say, companies above 50 employees. Say when you take company law, say you take an unlimited company which would publish very little information about the internal workings of their structures. So if you take an unlimited company of, say, 200 employees, where they, under the Companies Act, there'd be very little information about how they operate. How do you? What will their legal obligations be versus their present obligations under the CRO, and how do you square that legally?
Well, we're starting off, first of all, Chair, we're in the hands of the Houses with respect to the commencement of it, obviously.
Yeah.
We have to go through report stage yet and so on here in the Dáil. The requirement is that companies with initially with 250 or more employees will carry out a wage survey and publish that, and that will be mandatory. And then over time then, as we learn from the larger companies, and we've engaged with the unions and with the employers on this, and everyone is in agreement that this is the way to go. The larger companies have the wherewithal and the capacity to do these wage surveys and to publish them. And then as we move forward, we'll be moving down to the smaller companies, and they'll be learning from the larger ones. They'll be sharing information. And eventually we'll bring it to 50. We won't go below 50 because you're into a situation in where you could be identifying individual salaries and wages of individual workers, and that's something obviously we want to avoid.
I have to do a piece on the radio there in a minute, so with your indulgence, I just want to take, with a view to report stage, the opportunity just to identify areas I might introduce amendments, if that's okay? That's okay. Yeah, just firstly, just in relation to allowing the the Low Pay Commission to examine the structural pay inequalities is one potential area. An area in relation to gender breakdown of full-time employees, part-time employees and employees with flexible working hours contracts, to change the size of companies these regulations apply to and the time at which they'll apply and the various number scales and time scales. The area to ensure that the legislation applies to legal partnerships and multidisciplinary practices, to ensure that the employer narrative attached to it is mandatory, and to ensure that where people are not complying, that they can potentially that they're not publishing it, that they can potentially face fines or have their name published in a report by IREX. So just with a view to the report stage.
Thank you very much.
Yeah, okay. We note all those points as well, and thank you for that. Yeah.
Okay. Well, with that, then I propose to proceed. So, first is that Section 1 stand part of this bill.
Agreed.
Agreed. Thank you. Section 2 should stand part of this bill.
Chair, I have a number of issues to bring to your attention.
On Section 1 or Section 2?
On Section 2.
On Section 2.
Yeah, thank you very much. Section 20A1 sets out the information that regulations will require to be published. This is one aspect. There's one aspect that I may consider further and possibly table a report stage amendment, namely whether differences in bonus pay should be reported on a per hour basis rather than as a difference in the total bonus pay. The argument would be that if staff in a particular category or department in a firm get a bonus of, say, 2% of their pay, a woman who works part-time, therefore, by reason of this, earns less than a full-time employee, will automatically have lower bonus pay. So we'll have to consider this further.
Okay, thank you, Minister.
Also, there are a few other points in Section 2 as well that I want to just bear with me for a moment now until I just get to it here. Yeah. Section 20A6 provides for the publication of gender pay gap information by each government department, scheduled offices, and Garda Síochána and the Defence Forces. And I want to signal that we give further consideration to this subsection with a view to ensuring that it covers public service organisations in a comprehensive way, and I will bring forward a report stage amendment if necessary. And that's it in Section 2.
Section 2. Right. I propose that Section 2 stands part of this bill. Is that agreed?
Agreed.
Thank you. And I propose Section 3 stand part of the bill.
And again, Chairman,
Minister,
I have Section 3. Section 85C enables the Irish Human Rights and Equality Commission to apply to the Circuit Court for an order requiring a person to comply with the regulations. A person who fails to comply with the Circuit Court order is in contempt of that court. This represents enforcement by civil means rather than by the creation of an offence. For example, if we were to create a summary offence with a maximum fine of €5,000, is there a danger that some employer would be happy to ignore the regulation and accept the fine? Because with some large companies it would be a small issue. To prevent this from happening, the bill provides that a court order can be sought requiring the person to comply. If they fail to comply, they are in contempt of court. I wish to consider further whether this mechanism can be improved. A key issue would be if the person persists in their contempt, what power does the court have to deal with that? In the light of further consideration on this point, I may bring forward a report stage amendment.
Thank you. So the proposal is that Section 3 stand part of the bill. Sorry, you have an additional?
I have one more. Section 85D allows for an employee to make a complaint to the Workplace Relations Commission of non-compliance with reporting regulations by their employer. The Director General of the Workplace Relations Commission will investigate the complaint if satisfied that there is a prima facie case, or if on investigation the Director General or an adjudication officer finds in favour of the complainant, he or she may make an order requiring the employer to take a specified course of action in order to comply. This is the only remedy that may be ordered. For example, compensation may not be awarded as it is not an appropriate remedy in this situation. Enforcement of WRC orders is through the District Court. The idea here is that if an employer is in breach of the regulations, for example, the employer hasn't published the required gender pay gap information, apart from proceedings by IREC under Section 85C, an employee employee of the employer concerned can take proceedings in the WRC. Since the Workplace Relations Commission is rightly a very accessible and low-cost way to take a complaint, this has to be a protection for the employer. And for this reason, the Director General or an adjudication officer will only investigate a complaint if he or she is satisfied that it is a prima facie case. As I have stated, enforcement laws under the section will be through the District Court, and the same issue arises as for Section 85C. For this reason, I may return to this at report stage along with Section 85C, and I will table an amendment if necessary.
Okay. Are you finished now? It's on Section 3?
That's Section 3 done.
Thank you, Minister. So that Section 3 would stand part of the bill. Is that agreed?
Agreed.
Okay, thank you. Now we move to Section 4 to stand part of the bill. Do you have any comments, Minister?
It's purely technical.
Okay. That Section 4 stand part of the bill. Is that agreed? Thank you. Section 5. That Section 5 would stand part of the bill. Is that agreed?
Agreed.
Agreed. Thank you. That Section 6. That Section 6 would stand part of the bill. Agreed. Thank you. Section 7. Section 7 would stand part of the bill. Is that agreed?
Agreed.
Okay. Now I'm going to move, having done that, to the title. So, if you bear with me for the glasses, that the title shall be. That the title to this bill shall be An Act to Amend the Employment Equality Act 1998 to require regulations to be made that will require certain employers to publish information relating to the remuneration of their employees by reference to the gender of such employees for the purpose of showing whether there are differences in such remuneration referable to gender, and if there are such differences, the size of such differences, and to require that such employers to publish statements setting out the reasons for such differences and the measures, if any, taken or proposed to be taken by those employers to eliminate or reduce such differences, to make a consequential amendment to the Irish Human Rights and Equality Commission Act 2014 and to provide for related matters. Is that agreed?
Agreed.
Agreed. Thank you very much. Now, with that done, as consideration of the bill has been completed in accordance with Standing Order 90, the following message will be sent to the Clerk of the Dáil: that the Select Committee on Justice and Equality has completed its consideration of the Gender Pay Gap Information Bill 2019 and has made no amendments thereto. I again would like to thank Minister of State Stanton and his officials for attending here this morning, and this Select Committee is now adjourned sine die.
Thank you.
Thank you very much.